Thank you, Rachel. And we are going to play you later some of the testimony from Jonathan's wife, Megan, again, who was shot in the leg when this happened. And she testified basically in front of the people that she believes murdered her husband. This has been a really emotionally charged case, but I want to talk a little bit more about it now and break it down. So joining me on set is trial attorney Brad Micklin, and we're very happy to have him. Brad, it's great to have you here on the program for the first time.
Thanks, Jesse. I appreciate coming in. I love the show, big fan.
Well, thank you for that. So let's talk about this case. There's a lot of moving parts in it. You have a Marine who was killed. You have a wife who was testifying against the defendants. And these guys, their defense attorneys have said systematically that the police made a mistake here, that they went with a narrow view, automatically said that our clients did this, when they're trying to say there's all this evidence that maybe they didn't. What do you think about it from a general perspective?
Well, I think it's interesting. You know, as a defense attorney, you're always going to try to poke holes into the prosecution's case. But I think even more important than those points is the testimony from Megan herself, as you alluded to. You know, if she were to get on the stand and say, you know, you're the person that shot me in the leg, or you're the one that shot and killed my husband, I think that would have been the literal nail on their coffin. But she didn't say that. And what she did say was that she couldn't, or at least didn't want to, identify the assailants. And I think that's going to really, really play large into the defense position here.
These guys have distinguishing characteristics, including a face tattoo on Mr. Canada. The defense made a big point yesterday, poking that out, and during that police lineups, they actually covered it up. They covered it up because, according to the police, they couldn't find other people with face tattoos, and that wasn't an identifying feature that was described. So they actually covered it up because they said if they kept the face tattoo in a lineup where everybody else didn't have face tattoos, it would have suggested something to the victims who were trying to point them out. Does that make sense to you?
You know, it's hard to say really at this point whether or not it makes sense. I think, again, as a defense attorney, you're going to do as much as you can to have as many different items to poke holes into. And I think alleging police misconduct is always going to be a popular theme. You know, there's a lot of history in high-profile cases where that's been alleged, and it really plays into the hands of the jury.
All right. Well, we'll talk more about this case in a minute. But before we go to our main trials, the ones that we're talking about here today, I want to bring you all back and talk about our top crime stories here on Law and Crime. These are the biggest news stories in the country in a legal perspective right now. Let's play you that right now. Thank you, Anthony. Wow, those are some stories really to follow. Go to lawandcrime.com to learn a little bit more about them, as well as some of the top legal and news stories, again, on lawandcrime.com. But let's talk a little bit more about that Russian roulette story. Brad, my question to you is, why were they charged with murder? I mean, they said it's a modified version of Russian roulette, but I'm imagining if Russian roulette went bad, murder wouldn't be the charge. What am I missing here? Well,
I think there's a couple issues that are going on here, and it's going to turn and develop as the story continues, because I think we're just at the early stages of it. But the story seems to be that the defendants are at least claiming that it was Russian roulette and that the victim himself may have actually pulled the trigger. While that may be true, and that would certainly limit or reduce their culpability, but at the same time, even if that were the case, if they were involved in this incident or they brought the gun, their intent may actually transfer over into a different crime or into murder, even though they may not have actually intended to kill him.
But is there evidence that they wanted him dead? I mean, I read a little bit about this story, and it seems that they might have had a grudge against him, and might have been something going on that we don't know about yet. Have you read about that?
Well, there's a few things that are in the news right now, and the main thing that I've heard about is a social media post from one of the alleged defendants, where there's a question that maybe he admitted to this crime and maybe there was some motive. But the problem with social media is, although it's been with us for a long time, its use in the courtroom is relatively new. So there's always questions surrounding authenticity, admissibility, and then also just credibility. You know, how many times have you seen a Facebook post from somebody saying something about how great their life is, but then you get to know the person's really not that case? So the mere fact that they posted something that may have suggested their involvement doesn't necessarily mean that it's accurate.
In these kinds of cases where people victims take a role in a very dangerous activity, is there any defense that they assume the risk of what's going to happen? Again, we don't know all the details of what's happening in this case yet, but if they were involved in consensual Russian roulette, which I can't believe I'm saying, and ironically this happened in Las Vegas, I mean, this is not the kind of gambling I think anybody wanted, but again, is that a way that the defense could say, look, he assumed the risk?
You're meaning the victim?
Meaning the victim.
Well, I mean, to some extent, certainly. If you are engaged in a dangerous activity like that, or even playing with a loaded gun in any way, you're certainly assuming some of the risk. That doesn't necessarily negate the fact that the other two individuals who were involved didn't cause or create a dangerous situation that led to his death.
Weird part about it is I hear that, again, one of the victims, one of the defendants allegedly shot him point blank in the face. How is that a modified version of Russian roulette? My understanding was that the victim will always pick the gun up and put it to his head or to his face and pull the trigger. I guess that's where things get a little weird for the defendants.
Well, and it's going to be a troubling defense because, you know, we know what Russian roulette is supposed to suggest, but we don't really know what happened here yet. So it's going to be really important to find out how he died, where the gun came from, whose fingerprints are on there. I think once these pieces start to come together through the testimony and in the media, then we'll have a better sense of where the case is going to go.
It's a really tragic case. We're going to follow it more here on Law and Crime. As soon as there's an update, we'll make sure to let you know, as we always do. And again, go to lawandcrime.com to learn a little bit more about it. But let's switch gears and focus back on the Marine case that we've been focusing out of Kentucky. These two men who are charged with the murder of this young Marine, Jonathan Price, as well as injuring his wife, Megan Price. Now, that is what I want to talk about right now. Megan Price, her 911 phone call was played for the jury. And this is not just any 911 phone call. This is the call she made right after the shooting and the robbery. Her husband is lying on the ground bleeding out. She was shot in the leg. I want to play you this 911 phone call right now. Let's do that. That was Megan Price's 911 phone call after her husband, Jonathan Price, was shot in the back and after she was shot in the leg. So what impact did that have on the jury? That becomes the question. Let's bring back in trial attorney Brad Micklin. I'm going to ask you that question. What impact do you think that had when the jury heard that?
Well, I mean, it certainly brings the case home. I mean, you know, your heart goes out to Megan when you listen to this tape. But it offers, I think, very little for the case itself. I mean, there was a brief description of dreadlocks and the color of the assailants, but I think it was used more for the heart-wrenching aspect of it to really put the jurors in the moment of what was happening to her and her husband. And I think that's usually to play more on the emotions of the jury than actual facts of the case.
Dreadlocks. Quincinio Canada had those dreadlocks. We show you his mugshot all the time on our network. That is a really strong distinguishing feature. Now, again, he was put in a lineup where there were other people with dreadlocks, but he was picked out. This seems like a very strong case against the defendants. Would you agree?
Well, it's hard to say. A lot of people would believe that the case is strong against them because of the identification both of Megan Price, but also the victims in the hotel incident a few days earlier. But at the same time, there was also mentioned in the defense opening statement that there's DNA evidence that was found that doesn't match either of the defendants. So it's going to be questionable how that actually gets introduced and whether or not that actually hurts or helps the identification issues.
Taking a step back, I keep forgetting, by the way, that this case has taken, what, 4 years to finally get to trial? That has been an issue of itself. Why has this case taken so long to finally get to trial there in Kentucky?
You know, it's hard to say. You know, as you know, we have a right to a speedy trial, but you also need to have a fair trial. So there's a lot of issues that are going to play into any type of litigation, especially a murder case like this. I mean, you have a long period of discovery where you have to get investigations and witness statements and exchange information. There's also always going to be a lot of pre-trial motions to exclude evidence or to bring in or out different people that will be testifying. And then I think lastly, after you get past all these hurdles, you have a lot of people's schedules. You know, we forget that the court system is really just made up of people. So you're always going to have, here you have several attorneys, you have a judge, you have several victims and families. I think coordinating all these people to get together to start a trial is also going to be a very large consideration.
I think the scheduling of the public defenders was a big issue because they had other cases lined up. The judge in this case, I believe her name is Judge Goodwine, was not happy about pushing this off and pushing this off and pushing this off. I think it was either last summer or last spring when she really got fed up at this. But here we are today. The trial is finally happening, and we are covering it here on Law and Crime. We talked a little bit about Megan Price, really a widow now, the widow of her Marine husband. We played you her 911 phone call, but now I want to play you her testimony in court. This is, if not the most, I would say probably the most important witness in this whole case. So let's play you that right now.
At some point, did you and Jonathan go outside?
We did.
Okay. And what were you going to do after that?
We went out to talk.
Back into it as soon as we have it, because I want to play you Megan Price. She is, again, the widow of this Marine husband, okay? And this Marine husband, it seems, was just trying to protect her from an armed robbery gone bad. Now, what makes this as an interesting case is we talk about the gun. So the gun that was allegedly used was the same gun that police say was stolen from a Quality Inn 6 days before. That these three individuals who were staying at a Quality Inn, two of them were paramedics, that they were there for, I think, a gun knife show, and all of a sudden these two men walk around the corner from the Quality Inn and hold them up at gunpoint, push them back into the room, steal a bunch of their things from their room, including a gun that belonged to one of the victims. That gun, prosecutors, investigators say, is the same gun that was used to kill Jonathan Price. And they are using that bit of evidence to say that this is the defendants. These are the defendants who did this. And it's a really sad case, and we're trying to understand a little bit more about it. And Megan Price was talking a little bit more about it, and we're going to play you this clip as soon as we have it, where she talks about having trouble to first identifying the defendants. And that became a big issue in this case, because the defense attorneys have said, wait a second, prosecution? No. You targeted our defendants immediately. There were tips coming in. There was even an attorney with a tip about this case, and you chose to ignore all of it. Look at the DNA. DNA that was underneath Jonathan Price's fingernails, that didn't belong to any of the defendants. And the gun, which I just mentioned, was not in the hands of the defendants. Nope. This gun was found in the hands of a different individual named Antonio Fry. But he wasn't checked out in terms of this case, and why? That's really what the defense is trying to say. Okay, we have Megan Price's clip for you right now, so let's play you some of her testimony right now. Okay, that was some of the testimony of Megan Price, and that is really one of the key witnesses in this case. She is the widow of Jonathan Price, that Marine who was killed, and the question becomes, who killed him? That really is the question. And we're trying to understand what happened in this night when, I think it was 4 years ago when this happened, and trying to understand, why is Jonathan dead? So let's bring back in our very special guest, trial attorney Brad Micklin. Any witness, including a person who was right there during the shooting, how do we judge if we're sitting in the jury? How do we judge everything that they saw and everything that they heard 4 years ago, especially when she was the person who got shot in the leg? So I imagine the defense would try to pick up on that, or at least put something in the minds of the jury that, you know, her recollection might not be everything you imagine.
Well, yeah, and there's mixed opinions about that when it comes to trial work, because some people think that your identification, your memory is poor when you're in a high stress environment, and others think that because your life is on the line, you actually have almost a photographic ability to remember everything. So it's hard to say, but let's not lose sight of what her actual testimony was, and that was that she can't, or at least she said doesn't want to, or isn't able to name the defendant. So it's not a question of whether her recollection is accurate or not. There wasn't really a recollection that ties the defendants to that incident.
So in other words, what you're saying is it actually validates her in a way. Look, it's not like you said, she came and said, these are the guys who did it. She said, I didn't want to come out at first and make a mistake. So I think that adds credibility to her. That's what you're saying?
Yeah, I think absolutely. I mean, let's not lose sight of the fact that this is a death penalty case, and I'm sure that she's aware of that fact, because she didn't say that she's not able to identify them. The testimony sounded more like she didn't want to. She didn't want to make the wrong choice. So while we can't measure what her losses were in this incident, she's still going to be hard-pressed to say these people's lives should be taken when she can't be absolutely certain.
What an impossible position to put her in, first testifying about the loss of her husband, and also now having to say that every word she says could sentence 2 other people to death. But let's learn a little bit more from Megan about what these assailants look like. Let's go back. Wow. Wow. That is really compelling testimony right there. And I'm trying to think about what is going through her mind. Again, this is the widow of a Marine who was killed, and 2 men are on trial for his murder. Let's bring back in Brad Micklin. What do you think's going on in her mind as she's looking at them and saying the man in the white shirt, and she's looking at him and looking at him? What do you think's going on in her mind?
You know, it's really hard to be able to tell what's going on in the mind of a person who's been through such a tragedy. You know, this story doesn't get more sympathetic. You know, here is a young couple, you know, good-looking, young, married. You know, he's a Marine. He's, you know, pledged his life to protecting our freedom. He's out celebrating her birthday and loses his life by sort of defending her honor, you know, trying to protect her. Even if I don't think it was $60, as you mentioned earlier, I think it was her safety that he was actually trying to protect, and he gave his life for that, which is what Marines do. So to speculate what's going on in her mind while she sits there, it's impossible for us to know.
It really is. And you think about it, we cover a lot of cases here on Law and Crime where there's a relationship between the defendants and the victims. Here, this is just, these 2 men really had no relation to the Prices at all. And, you know, it seems like with these kinds of acts of violence, it just, why did it happen? You know, I keep asking myself, why did this happen? And it could be them, or as the defense are saying, that there's somebody else that might have been blamed. But whoever did this, it seems that it had no relation to the victims, which is eerie. I find that very eerie. What do you think?
Well, it is strange, and even more odd about this case, there are several different victims, several different incidences. You have the hotel incident where the gun was taken, then you have this murder, and then the alleged murder or crime spree that they committed after the murder. But part of me wonders if this is more the prosecution's attempt to link the defendants to this murder, to the gun. So you have to bring in the hotel incident, and then you have to bring in the murder weapon. So it's sort of like they're trying to put their pieces together in this puzzle. But that may actually seek to backfire for the prosecutor, because at the same time, you're leaving a lot of places for the defense to poke holes into the story. Now, I know there's already talk about whether or not the gun that was recovered was black or silver. There's questions about the person that they actually found the gun from.
Let me ask you about
who wasn't even charged apparently in this incident.
Let me ask you about the gun. Why would they, if this is all true, why would they use a gun they stole from another robbery in this crime? Why? Doesn't that seem like, why do that? If they had guns during the robbery at the Quality Inn, why not use one of those weapons?
Well, I think you're trying to put some intelligence into people who probably didn't have a great level of intelligence. I mean, one way or another, these are violent criminals. If they're tied to any one of these incidences, even at the end, the man who had the gun was trying to sell it unlawfully to an undercover agent. So you can't really expect, you know, rational, intelligent choices when you're looking at this kind of behavior.
That's fair. That's fair. I'll go with that. Let's go with that. Here's what we're going to do. We're going to take a quick break. When we come back, we have a lot more of Megan Price's testimony to play for you, including the moment when her husband was shot. We'll be right back. Welcome back, everybody. That was the emotional testimony of Megan Price, the widow of Jonathan Price, who was murdered in cold blood after this botched robbery attempt in Kentucky. 2 men are on trial for his murder, and we want to talk about that a little bit more about this case with Brad Micklin right now. Thank you for joining us, Brad.
My pleasure.
Here's my question to you. This case, where the defense has said that this is about a matter of mistaken identity, right? They're saying that you have the wrong suspects here. The DNA evidence will exonerate my clients. There were, let's talk about the robbery that happened 6 days before this shooting that Megan just talked about. 3 people were held at gunpoint. They alleged that it was these 2 men, Quincinio Canada and Dewan Mulazam, the same men that are alleged to have shot Jonathan. But the testimony of these 3 people, I didn't feel 100% confident about it. So the defense first poked the hole in Mitchell Smith, who had a racist Facebook post. Then Jessica Hansford said that she couldn't 100% identify anyone from the photo lineup, and the only person that could identify somebody was, I think, Shane Hansford. I believe that's his name. Shane Hansford, who owned the gun that was allegedly used by these defendants in the Jonathan Price shooting. He was the only one who identified Mulazim from the shooting in the lineup. So you have one who might be tainted, one who wasn't sure, and then one who could only maybe identify one of the suspects. What do you think about that? These are 3 victims. Who better to know about who did this than them?
Yeah, I agree. I think it's very significant. I think identification is a huge issue, and probably right now the strongest point that the defendants have. You know, that Facebook post goes not only to undermine the credibility of the testimony, aside from the racial aspect of it, but it completely undermines the identification, which is crucial. Which, you know, sort of brings us back to that Russian roulette point we were talking about with social media, is that, you know, you're putting something on social media which was just a ignorant comment, and now it's going to undermine a capital murder trial. You know, and that's why I think, you know, for instance, I tell all my clients, I say, stay off of social media during your cases, because just no good comes from it.
And what do you think about this DNA evidence? The idea that the defense said, well, if you look under the fingernails of Jonathan Price, they don't match, that DNA doesn't match any of the defendants. What do you think about that?
Well, it's an interesting point. You know, DNA, first from a jury standpoint, I think is always a significant issue, because it's very complex. And if you're looking to just create reasonable doubt, you know, DNA is probably the easiest way when you're talking about a jury of lay people. But more importantly, it's interesting that they're even making it an issue, because I don't remember any testimony that there was a struggle.
Well, didn't she just say that? Didn't Megan just say there was some sort of scuffle, that there might have been an altercation between her husband and the 2 assailants?
I'm not really sure, and I don't know at this point whose nail was the DNA and when it was found. So it's kind of convoluted at this point, and it may just be being introduced as a red herring just to create more doubt, or there could be something seriously that undermines the prosecution's case with the identity.
Well, it does sound good for the defense to say, I mean, just the statement that if you look at the victim's fingernails, there are no DNA of the defendants. I mean, it's just a good statement to say and put in the minds of the jury. Will it ultimately create reasonable doubt? Maybe, maybe not. We'll have to see. But let's play a little bit more of Megan Price's testimony. Again, a crucial witness, if not the most important witness in this case. Let's play it for you right now. That's the emotional testimony of Megan Price right there, the widow of Jonathan Price, who was murdered in cold blood, and she was shot in the leg. Imagine that for a second. So if not only that, not only do you see your husband lying on the floor, blood coming out of him, he's bleeding out, but you're shot in the leg and can't even go to help him. How helpless does she feel? And let's talk about that a little bit more. I mean, that testimony, Brad, is so emotional from so many different levels. And it wasn't even that she felt helpless and terrified about what happened, but she was shot in the leg. And according to her, that the bullet entered her leg, shattered a bone, exited her leg. She has a metal plate and 9 screws helping to hold the bone together. She said that she'd have to endure another surgery and another painful recovery period if she wants to have the plates removed. So she is a victim from multiple angles here.
Yeah, I would agree. You know, some people will say time heals all wounds, but this is one that I don't think time will. You know, aside from the tragic loss of her husband, she has a permanent injury, and it all happened, you know, on or around her birthday. So she's going to have this painful reminder every time that she moves, every time her birthday comes up, anytime her family's together. So I think, and we could hear it in the tape, I mean, that kind of trauma is just going to be relived, I think, over and over again by her.
Yeah, she said her left leg, where she was shot, is now shorter than her right leg, creates issues of balance and back pain. I mean, and as you said it so well, this happened on her birthday. It's going to be a constant reminder for her, and this is just a tragic case. And we talk about what was happening in her mind during this whole event. Well, I want to play her 911 phone call again for you. This is right after this shooting took place. Let's play that right now. Unbelievable. Really tough to hear every time we play it. Wow, that was the last moments of Jonathan's life. That was the last words she had with him, or at least before he was shot right in the back, right through the heart, bleeding out on the floor. That's really difficult testimony to hear. Really tough. But let's talk a little bit more about what's happening in this case. Here's my question to you, and it's something that always been going in the back of my mind. He was shot, she was shot. These same men are alleged to have 6 days before engaged in a robbery. Why didn't they, and I'm happy no one else is injured in this case or anyone was killed, but if they showed their faces, and it's clear that they did, to the 3 victims at the Quality Inn, why didn't they take action against them? I mean, they showed their faces. Why didn't they shoot them?
Well, it's hard to say. I mean, either at the hotel, there's some question about how much the witnesses actually did get to see them, because I think they were told to lay down on their back. So, their involvement from the assailants, I think when they saw them approaching, was more so than when they were actually in their presence. And you got to couple that with the fear and anxiety that's obviously going to race through your mind. But again, I think this is all part of the prosecution's case to try to tie all this evidence together. They have Megan, who can't really give you a strong ID. You have the hotel victims who can't really give you a strong ID. So I think they're just saying, if you can have enough people give a little bit, when the jury puts it all together, maybe you'll have a strong identification for these defendants. Because otherwise, I think individually, it's not going to be enough.
Well, according to one of the victims from the Quality Inn, he heard, I believe it was Dewan Mulazim, say to Quincinio Canada, "Come on, nephew." Mm-hmm. Now, that's a big statement to make, because how many uncle-nephew crime sprees do we have like this? I mean, that's a big identifier.
Yeah, I think that's going to be a really big point later because of the problems they're having with identification. When I first heard that, it did seem strange, and it couldn't be coincidental that the 2 people that are in this crime are nephew and uncle, and that there's a reference or calling each other that. And given the problems that the prosecution's having with the identification, I think they're going to really try to hammer that part in their closing so that they can really tie all this little pieces of identification to something that's really meaningful for the jury.
All right, well, let's do this. Let's play a little bit more of Megan Price's testimony from this case. Again, such a critical witness, and I know it's difficult to hear what happened to her husband, what happened to her, but it is important testimony in this case of 2 men who face the death penalty if convicted of shooting and killing her husband. Let's play that for you right now. Welcome back, everybody. That is Megan Price explaining what happened to her on the night of the shooting. And she not only suffered the loss of her husband, but she also suffered herself. Was shot in the leg. She has a metal plate, back pain, trouble balancing. Really a horrible situation. Let's bring back in Brad Micklin. I want to just touch upon the last statement she made in that clip where she said, I didn't want to be responsible for making the wrong choice. In terms of that lineup. What did you think about that?
Well, I think that's the most crucial part of her testimony, because she's not saying I can't identify them. She's not saying that I don't know if these are the people that attacked us and killed my husband. She's saying that I don't want to be responsible for the wrong choice. And given what she's gone through, it's pretty remarkable. I mean, even when you listen to her 911 tape, what's remarkable about that in and of itself is, in the very beginning, she's actually able to keep it all together when she's on the phone. She can describe her injuries, she's describing what they look like, and she's almost calm. And I think it's at the point where maybe she actually started to see her husband on the ground that she started to really lose it. So, she's got a really strong character, and I think it's that character that's keeping her from saying it's these 2 men with certainty and they should be put to death.
What an impossible position to put her in. It really is. It's a really, really tough position. Here's what we're going to do. We're going to take a quick break, and when we come back, we have a lot more to discuss, including we want to update you on the North Carolina case, the Wallace Bradshaw case. A lot to discuss there, so we'll be back in a minute. Thanks, Anthony. Go to lawandcrime.com to learn more about the top legal, crime, political, entertainment stories of the day. That's where we have it, lawandcrime.com. But let's talk a little bit more about that Russian roulette case. I'm here with trial attorney Brad Minkler. This is strange. A 17-year-old and a 16-year-old are both charged as adults. What's going on?
Well, I think it's sending a serious message. The juvenile system is about rehabilitation.
And Brad, let me sorry to interrupt. Brad Micklin. I messed that up.
Yeah,
See, your first time on the program, and I keep messing it up. Brad Micklin.
I let it go because I want you to invite me back. So.
My apologies.
That's okay.
Please continue.
So like I was saying, the juvenile system is about rehabilitation. So the punishment is always going to be significantly less, especially if there's never any death penalty. I think when you have children, if close to the age of majority, the legal age, and you have a heinous crime like this, I think that they want to have more severe punishment so it deters other people from committing these kinds of acts. But I also think there's an issue about the actions of these kids and the lack of either responsibility or accountability. And I think the story that I heard was after this, they were either posting on social media and they were either in a stolen car or at least driving recklessly, which shows almost an indifference to what they had just done, whether it was intentional or not. And I think that played a part in the decision to try them as an adult.
And what could ultimately happen to them if they are found guilty of this?
Well, it's hard to say because I'm not really sure about Vegas's laws about death penalties and things like that, but the punishment is going to be the same as it would be for an adult.
Now, here's the weird part about it. We talked about it in the preview, in the report from Anthony, that it was a modified version of Russian roulette. Now, I don't know what that means, but if he was shot in the face by one of these guys, that's not the Russian roulette that I have always heard of. It was always my understanding that the victim in this case, and when I heard Russian roulette, I assumed when I first read about it, he took the gun, put it to his head, and it was an accident of some sort. That doesn't appear to be Russian roulette.
Yeah, I would agree. I actually noticed it in the clip earlier. I originally thought that the use of the term Russian roulette was really just to kind of put a spin onto it. You know, it's in the media. But when they say modified, it suggests that there was something that happened, and we're not really sure who pulled the trigger, and that may be why it's modified. Or, you know, I'm not really sure how Russian roulette's really played, but I understand that, you know, typically there would be one bullet and then it's randomness, you know. So there could be that the gun was full of bullets. You know, it could be almost anything. We just don't know at this point.
The mother of this Mr. Micklin, he said that Caruso, one of the defendants, had a beef with him, and that this really wasn't an accident of some kind, and perhaps that's why the Russian roulette theory came forward. So it adds a little bit of gray to here. But if there was really a situation, and the details are still coming forward, where a modified version would be, okay, we spin it, and then I point the gun at you, pull the trigger, you point at me, is there any way this could be defended as an accident?
Well, I mean, it could be defended as an accident. It's not necessarily going to negate the gravity of what they did.
Because I'm assuming then that they would say, look, the victim assumed the risk here. The victim assumed the risk.
And that's possible. You know, it's very hard as a defense attorney to make the victim the cause and to blame the victim in a trial before a jury. So you kind of have to tread lightly there, but I'm sure they're going to try to do something to at least remove the blame from the two kids that were involved and try to place it as sort of gently as they can onto the victim himself.
Well, it is definitely one case to follow, and we're going to follow it here on Law and Crime. And go to lawandcrime.com, and there we will basically cover this case as well as the other top crime stories of the day. But let's take a step back and go to North Carolina. Let's talk about Wallace Bradsher, this district attorney who is in some pretty hot water, faces 6 felony counts and 1 misdemeanor charge. You see him right there. Defended himself in this case. And if found guilty, could face 18 years in prison. And for what? For allegedly engaging in a scheme to hire another district attorney's wife, Craig Blitzer, hired his wife, Cindy Blitzer, which is not illegal, but this is sure illegal, if he paid her $48,000 and she didn't do any work. That's a problem. It's alleged that he authorized her to keep going to nursing school, taking classes, keep collecting paychecks, cashing those paychecks. He knew about it, authorized it, prevented her from resigning, allegedly said that he had unfettered discretion to do what he wanted in the office, and tried to cover all this up, tried to cover this whole scheme up. Those are some pretty serious allegations. And we were waiting for Mr. Bradsher to tell his side of the story. He was able to do it a little bit in cross-examination, didn't take the stand himself, which we thought that he might, considering he asked questions to the judge about if he wanted to take the stand, what the format of that would look like, but he ultimately didn't, and he didn't call any witnesses on his behalf. But he did present a closing argument, and that's what I want to play for you right now. This was Wallace Bradsher's last attempt before the jury went in to deliberate to tell them his side of the story. Let's play that for you right now. That's Wallace Bradsher defending himself. He faces 18 years in prison if convicted of these really bizarre crimes in connection with a bizarre scheme to hire another district attorney's wife and pay her $48,000 for work she didn't do. And he is trying to appeal to the common sense of the jury in his closing argument, and I want to see if that was effective from our very special guest, trial attorney Brad Micklin. Brad, good to see you.
You're getting it right this time, Jess.
I'm going to ask you the same question that I've asked everybody on this case. Does it make sense to you that he didn't get any money for this scheme, that he worked so hard to protect Cindy Blitzer and Craig Blitzer and make sure that she kept earning this money? He didn't gain anything from it. She said she wanted to resign, and he said no. What am I not getting here? Something about that doesn't make sense, and you heard the flavor of it in his closing argument.
Yeah, and I didn't hear much testimony during the case about her involvement, Blatcher's wife's involvement. But we have to remember first, she was still working in the other district attorney's office. But also, from my understanding, the investigation that led to this trial began in part because Blatcher wanted to give his wife, who was then working for his office, like a 30% raise. And that kind of set off bells and alerted some people, so they started investigating it. Then we have this transfer to other offices. So she was, first of all, we don't know what her salary was when she was transferred, if she did or didn't get this raise. But then she was transferred to this other office where she's now working. And the thing about it is, you know, Cindy testified that not only did she not have to work, she didn't have to go in, which sounds like a perfect job to me. I would love a job like that. But can we really believe that he would have given his wife more work, but not to Cindy? If Cindy came into the office, who had, I think, was one case and then no cases,
right,
I can't really believe that his wife was working that hard in his office. And then she was moved to another office just to keep the salary. It wasn't about assisting him in his office any longer.
So you're saying something doesn't add up, right? Something doesn't add up about it. Again, he said, do you think that I would have told her, I would have refused her resignation, said I had unfettered discretion to do what I want, and then fire her a short time afterwards? Does that make sense? I mean, what does seem plausible here? Does it seem plausible that we heard the testimony from another individual who worked in the office, Jay Stultz, who was supposed to be the supervisor of Cindy, but then was not the supervisor of her, gave that to Wallace Bratcher. Wallace Bratcher said to him, look, I know you have a lot on your plate. I'll assign it to somebody else. Well, when this whole SBI investigation came forward, Wallace Bratcher called John Stultz in and said, what's going on with her hours? He said, I'm not handling them anymore. You were going to handle them. He goes, I never said that. Wallace Bratcher then authorizes him to release all of her hours to the AOC. And when John Stultz says to him, did she work these hours? He said, yes. What about this, do you think, like, let's break it down really from a practical point of view. This guy's a busy guy. He runs the whole office. I'm sure he's not looking at her day in and day out, what she's working on, what she's not working on. Is it plausible that she tried to reach him and tell him she had no work? Let's start there.
I think it's plausible, of course. I mean, many things would be plausible in a case like this. But I think the important points, which I mostly got from his opening argument, you know, he did a really good, compelling opening argument. You know, he pulled on your heartstrings about his 7 children and how he left criminal practice because he wanted to reduce crime in his hometown. So it was really compelling. But then he goes into talking about all of his attempts to circumvent the policy that prevented his wife from working there. He says, you know, he tried it this way, and then he tried this way. And then what he did, and this is what I thought was the most compelling in my belief of what he did, was he then spoke about what he called mistakes. You know, this was my first mistake, this was my second, third. I remember him getting up to 4th. And I think when you have a criminal attorney who claimed to be very successful as a criminal attorney, who's now an elected district attorney, knows this policy is in effect, and then continues to make what he alleges to be 4 different mistakes, is just not credible. I think he had a strong idea, maybe that it wasn't criminal, because it was an ethics issue in the beginning, but I think he was doing everything he could to keep the situation he had in place. And I think that while maybe Cindy did say that she didn't have enough work, I don't think he took any steps to rectify it.
Do you think he told her not to resign and that he had unfettered discretion to do what he wanted and deliberately tried to cover this up? That's the second part of this.
Well, I think a little bit of both. My understanding from the testimony is that there was state statutes that gave an elected district attorney unfettered discretion over his or her employees. So that's what I think he was referring to.
Okay.
But it then became apparent that you may have unfettered discretion, but it can't be your wife, that's the employee. So it's a separate issue.
Yeah.
You can have a dozen employees and you have constitutional authority over them, but it can't be your wife.
Okay, here's what we should do. So we heard a little bit from the defense. We heard a little bit from Wallace Bratcher about what he thinks actually happened. Let's now turn to the prosecution's closing argument and hear what they think actually happened. This was their last attempt to convince the jury that Wallace Bratcher is guilty. Let's play that for you right now.
And what I want...
Well, that seems pretty clear. That's the prosecution really hammering away about why Wallace Bradsher, this elected district attorney, really is not the good, innocent guy that he claims to be. But now we have an update in this case because we heard yesterday the jury, and they're still deliberating the fate of Mr. Bradsher. It will continue Monday. They asked some questions to the courtroom, and perhaps that will give us an idea of where they're headed in their deliberations. So let's talk a little bit more about it with Brad Micklin. Brad, I'm going to ask you the questions. I'm going to tell you what the answers are. Then you tell me what you think about it in terms of where the jury might be going. The first question they asked is, what is the date range for obtaining property under false pretenses, which is one of the charges? The answer gave back to them was jurors were told the offense dates for obtaining property by false pretenses occurred between April 1st, 2016 and October 24th, 2016. What do you think about that?
Well, it suggests that, the jury is probably trying to find out what was happening at a specific time. I mean, obviously, they were asking for dates. And I think because there's going to be an overlap, there's issues in this case, not just about the wife swap and the lack of work, but also did he cover it up?
Right.
There was a discussion that he fired an employee that may have been a whistleblower. So I think the jury may be trying to line up these dates to see if there's an overlap, to look to whether or not there's guilt or not guilt on certain offenses.
Okay, the second question they had was for count 2, what does representation refer to? And the judge said to apply the common meaning that it may take on many forms. Again, what can we glean from that? And just to let our viewers know, I believe the second charge is aiding and abetting. He's charged with aiding and abetting, conspiracy, 3 counts of obstruction of justice, a misdemeanor charge of failure to discharge the duties of his office, and again, that felony of obtaining property by false pretense. So what do you think about that question?
Well, it's hard to really address that question without the full context of the instruction itself. We're just given that one word. But routinely, in all kind of criminal offenses, the jury is charged with determining a mental state, a mens rea. So that word, that might be a specific definition that they need to find that he, in fact, did either have or act consistently with to be able to find whether or not he did commit the offense.
For count 2, does property only apply to salary and benefits given to Cindy Blitzer, or can it include salary and benefits given to Tyler Henderson or others? The answer given to the jury, property, refers to benefits and pay given from the AOC to Cindy Blitzer. That's an interesting question.
Yeah, I find that interesting also because whether it's given to one person or 2 people shouldn't necessarily make such a large difference, but it, again, may be at the different times, one person receiving a benefit, and then later we have a different person receiving it, and they're trying to piece together whether or not he did have the intention to commit these crimes, did he have the intention to kind of cover it up. So it could go to what his motive was as to whether or not he was giving certain people compensation or not.
And they're saying, let's just focus on Cindy here. Let's just focus. Maybe they were saying, look, we can't get him on Cindy, but maybe we can get him on something else, or maybe it's all together, maybe a few counts of it.
Yeah, it's hard to say because, Cindy wasn't charged with anything, which is
she was
large. Now, that's understandable, as many may think that what she did was horrible because she's taking money from the government, but it may not necessarily have been her obligation to get work. It was Blasher's obligation to give her work.
But she did say on the stand, I knew what I was doing was wrong. And you say that on the stand, it doesn't get any more clear than that.
Well, but that, and her husband did the same thing, but that's easy to do when you're given a plea deal that, one, she wasn't charged with, and I'm assuming that was part of Craig's deal, is that don't charge my wife, because he knew about the investigation 10 months before he even told her.
Right.
So there was obviously some kind of, he was trying to protect her because he gave up his law license in this plea deal. But it's very easy when you're given a deal that says you're not going to be charged, your wife's not going to be charged, and you won't go to jail as long as you testify against this other person.
Okay, final question that the jury asked was for count 1. Again, that's the false pretenses one. What is the, that's the conspiracy one. For count 1, what is the legal definition of conspiracy? Can you conspire for just letting things go on? For example, not being an active participant? They were told that an agreement may be verbal or implied by the actions of the party. What do you think the jury's thinking there?
Well, I think it goes back to that similar question they had about the representation. In order to find somebody's guilty of any criminal offense, there's usually going to be a mental state, something that was either they intended to do it or they negligently did it. So in order to conspire, there's going to be certain mental states as well as certain overt actions, I believe, that will be necessary to establish. And I think the jury's just trying to gather all that to figure out if it did or didn't actually occur.
Brad, that's very clear. We'll have to see what the jury will ultimately decide, and it's so hard to glean. We always take guesses about which way they're going to go. And more oftentimes than not, I'm wrong, so I'm not going to do that here. But again, jury deliberations will continue on Monday. We'll cover it here on Law and Crime, and we're fully analyzing this case, but that is not the only case that we're covering here on Law and Crime. We are focusing now on a horrific tragedy out in Kentucky about a Marine who was allegedly just trying to protect his wife when a robbery fight went wrong. 2 men are charged with shooting and killing Jonathan Price and shooting his wife, Megan Price. She was shot in the leg. She survived and testified earlier in this case. And the 2 men, Quincinio Canada and Dewan Mulazim, are charged with Mr. Price's murder, and they could face the death penalty if convicted. What I want to do is play the testimony right now of Detective Timothy Upchurch from the Lexington Police. This was the lead investigator in this case, and he had a difficult job because he didn't just investigate the shooting of Jonathan Price, but he had to investigate this robbery at the Quality Inn that happened 6 days before. And evidence from that crime scene is being used to link the defendants to that robbery to this crime. And they are being charged in connection with both of those incidents. They face robbery, assault, and murder charges. So let's learn a little bit more from Detective Upchurch about what happened in the investigation. Okay, so that was Detective Timothy Upchurch explaining how he investigated this crime. And remember, he was the lead investigator in this case who was investigating a robbery at the Quality Inn and tied it to the shooting of Jonathan Price 6 days later because the same gun that was stolen at the robbery at the Quality Inn was allegedly used to shoot Jonathan Price. And it is believed that Quincinio Canada and Dewan Mulazim, the 2 defendants, are the ones that committed both of these crimes. I'm here with trial attorney Brad Micklin to discuss this a little bit more. Tough job for this guy to investigate both crimes. And how difficult is it in your experience when you have 2 separate incidents, you're charging the clients for both crimes 6 days apart and trying to tie them to both crimes, but really the way that they're tying them is with a weapon that didn't belong to them specifically. It was a weapon that was allegedly taken from one of the victims, used in another shooting, and was ultimately found in the hands of a 3rd individual who's not one of the defendants.
It's an interesting sort of puzzle that they're trying to put together, and I believe the one defendant who did have an opening statement alluded to the incentive that the police may have had because there were a lot of high-profile murders that I believe were unresolved. So there's a claim that they were under pressure to actually resolve and to not quickly go to trial because it was some time. But there's a question of whether or not the investigation, which could be argued to be very convenient, that they were able to get all these different pieces together, or it could just be that that's his job. He investigates crime, and one crime will often lead you to another. I mean, it's hard to believe a person involved in such a violent crime that this would be their first initial offense, so it's not unusual that you might find subsequent or similar actions and crimes by the same people.
So the shell casing that was found at the Jonathan Price crime scene actually was the one that was when Shane Hansford, it was his gun at the robbery. They asked him to get a shell casing because he had fired that weapon before. They matched it together, and that's how they found it. But now let's talk about how they actually got the 2 defendants. And it was through a lineup. So the 3 victims in the robbery at the Quality Inn were asked to look at a lineup of these 2 individuals. One was a 6-pack lineup. That's when you have 6 individuals in a frame and you pick it out. And then there's a sequential lineup where there's one photo after another. Shane Hansford picked Mulazim from a 6-pack, while Smith picked Canada and another man from a sequential lineup. The other man obviously couldn't have done it because he was in, I don't say obviously, the other man couldn't have done it because he was actually incarcerated at the time. But then we learned that Mr. Smith, Mitchell Smith, who picked Canada out, he did a Facebook post that was extremely racist and said that all black people look the same. So how can you, and Mr. Upchurch was grilled under cross-examination, how can you say this is a reliable lineup if he thinks all black people look the same? And then the 3rd individual, Jessica Hansford, couldn't even identify anybody in the lineups. We talked about it earlier. This seems to raise a little bit of questions.
And I agree, Jesse. I think the lineup and identification issues is going to be very, very compelling in resolving this case, whether it's favorable to the prosecution or to the defendants. And there's always going to be problems with lineups because it's not just the procedure that's being followed, but it's usually, you're almost always going to have defense attorney there to watch the lineup. And they're looking for not just who was identified, but what questions were asked. You know, how long did it take them? How certain did they really seem when they made these identifications? And when you hear things like this post, aside again from the racial aspect of it, that suggests that he doesn't know what the lineup was or who was the offender. It's going to really create a lot of challenges, I think, for the prosecution to convince the jury that these lineups and these identifications are credible. Well,
let's learn a little bit how these lineups were created. We have Detective Timothy Upchurch from the Lexington Police. We watched him on the stand. He's about to go into, this is his prior testimony from yesterday, about how these lineups are created. Let's learn. That's Detective Timothy Upchurch from the Lexington Police testifying in this Marine killing case out of Kentucky. And now I want to talk about lineups because that is a big issue in this case. The defense counsel for Quincinio Canada and Dewan Mulazam, the two men who were charged with shooting this Marine, Jonathan Price, they made the point that these lineups were kind of biased and there was problems in the way that they were presented to the victims. Well, were they? Was there an actual bias? Let's learn a little bit more about them with Brad Micklin, trial attorney. So I want to ask you a couple of questions about this. The first part about this, Mr. Upchurch said that typically he doesn't record photo lineups, and he also didn't feel that he needed to because he had another detective who was present. He said he doesn't really record them because he doesn't want to make the victims feel uncomfortable. What do you think about that?
It's kind of a strange practice. I think given the nature of an investigation, and if there really were a lot of high-profile cases that were either resolved recently or unresolved recently, the fact that they're not going to record something that is so crucial to their case suggests almost that they may not want it to be recorded, that they might be concerned about inconsistent information and that the defendant's actually getting that. Like I referenced earlier, if it takes a long time for them to answer, or they ask questions, or they use vocabulary that suggests that maybe they're not certain, that would all be recorded and then played to the jury or even put into the defense closing argument. So I think the fact that he doesn't tape it could be problematic for them.
And is there any difference in your opinion about, okay, we're going to have individuals in a six-pack lineup where you see the 6 photos, pick someone out from there, as opposed to a sequential lineup where I'm looking through the photos. Do you think there's any difference there, and why separate the two? I mean, again, I just want to make sure I get this right, that Shane Hansford picked Mulazam from a 6-pack, while Smith picked Canada from a sequential lineup. Why have the two different kinds of lineups?
I'm not really sure why, but I know it's sort of going to be problematic depending on which one they're utilizing, because if you have the 6-pack and you have everybody there, I think the identification is a lot more powerful, because if you're going picture by picture and you're the person that you're about to make the identification, I think if you don't get through all the pictures, you might actually jump the gun and make the wrong identification. So I think that maybe prosecutors or the investigators had their own preference, but I think the 6-pack is going to be much more effective.
Oh, okay, I want to play the final clip right now of Detective Timothy Upchurch when he talks about not including anything suggestive on one of the defendants. Let's play that right now.
Law&Crime.
Thank you, Anthony. You can go to lawandcrime.com to learn a little bit more about those stories, but I want to talk about that Russian roulette story we've been talking about continuously on this program because we're learning new information about it, and we don't want you to miss anything about this case because it is tragic and bizarre at the same time. Let's talk finally, our last appearance here with trial attorney Brad Micklin. Thank you so much for joining us today. So I have my final questions to you about this case. We're learning new details about this. First up, it says that they never called 911. Detectives reportedly found F-Mat spray painted on the closet door where Minkler's body was found. Minkler's wallet was found in the stolen car that Mr. Harlan was allegedly driving, and he drove in a police car chase. They eventually caught up to him, and Minkler's wallet was in there. It's as you heard in that short report from Anthony, that Harlan allegedly said that he wanted to clean up the crime scene, or that he helped clean up the crime scene. And when they looked at Caruso's cell phone, one of the defendants, it said, bro, I just caught a body. It was a video of him saying that. And finally, the last piece of information that we just learned was that Mr. Caruso, again, one of the defendants, never allowed the other participants to handle the firearm or pull the trigger themselves. What do you think about these developments?
Well, I think some of these issues go back to your earlier question about why are they being tried as adults. There's always a chance when you have guns involved, that things can go horribly wrong. It doesn't necessarily mean that was the intention. It could have just been foolish and went tragic. But what you do after that says a lot about whether or not it was an accident or was it intentional. You know, if you accidentally harm somebody and then you call 911 to get that person help, well, then you're at least acting consistently. If you cover it up or hide it or brag about it, that suggests that it may not have been an accident.
But the revelation that if this is true, that he never allowed them to handle the gun, the defendant, never allowed other people to handle the gun, how on earth is this Russian roulette? How can you blame it on Russian roulette?
Well, we're not getting the statement from the victim. You know, we're
Right.
getting this from the people either that are on trial or the people that are representing them. I think there's going to be a lot about these, I hate to call them children, the two defendants. I think we're going to learn a lot about them in their past. We don't know anything about these kids, what they were like before this, what possible trouble they had before this. It may not even been the first time that they committed an act like this.
Investigators say that Caruso, again, one of the defendants, broke down and admitted to being involved. He said, though, it was an accident and that he'd been using Xanax. What do you think about that?
It's hard to comment. I mean, I don't really know the exact effect that the Xanax can have, and I don't know how much he claimed to have been using. But I don't know if that's going to be enough to negate his involvement. I don't know if it's going to be enough to say that what they did was tragic because he was under the influence. You still have, if you could commit these acts and you could take the steps to cover them up so carefully and methodically, then it's unlikely that the drugs or alcohol or any kind of substance he had actually affected his abilities.
Well, the mother in this case, Jamie Shanklin, who's the mother of this young boy, this 17-year-old who was killed, she said she believes that Caruso had a beef with her son. She doesn't believe it's an accident. She said, "My baby never came home. I've been mourning for days, and now I feel my anger." It's a really tragic case. We're going to keep covering it. As soon as we have an update about it, we'll make sure to let you know. But before we go back into our next case, I want to sign off Brad Micklin. Brad, it was great having you on the program. First appearance. Can't wait to have you back.
I'm looking forward to it, Jesse. Thanks.
Thank you. Okay, here's what we're going to do. We're going to switch gears. We're going back now to Kentucky, okay, for the two men that are charged with the murder of Jonathan Price, a Marine who was allegedly just trying to help save his wife from an armed robbery attempt gone bad. Now, we've been playing the testimony of Detective Timothy Upchurch, the lead investigator in this case. We talked a little bit more about it, this lineup. This lineup becomes such a big issue in this case because the defense is saying this lineup was tainted and it unfairly pointed the finger at my clients. Let's learn a little bit more about the lineup from Detective Upchurch.